If you are acting as an attorney under a power of attorney for someone who has lost mental capacity, you may wonder whether you are allowed to make gifts on behalf of the donor. The general principle, which is similar in England, Scotland and Wales, is that an attorney has the power to continue to make gifts that the donor was making. But there are many cases where you need to gain approval from the Court of Protection. Under English law, the most common power of attorney is called a lasting power of attorney, known as LPA for short, which was previously an enduring power of attorney, or EPA for short. Deciding whether to give a gift can be an important part of being an attorney. Gifts help to preserve the relationships with family and friends of the person whose finances you are helping to look after. However, you need to be aware of the strict limits on gift giving as an attorney. What counts as a gift in your role as an attorney may be broader than you are used to. Gift giving is not just using the person's money to buy something for someone else, including yourself, on a birthday or other customary occasion, or giving the person's money or possessions to another person. Gift giving in this case also includes donations to charities, paying someone's school or university fees, living rent-free or at a friends and family rate in a property belonging to the person, selling the person's home to someone at less than market value, creating a trust for someone from the person's property, giving someone an interest-free loan from the person's funds where the lost interest counts as a gift. Only when you are sure the person can't make or help to make their own decisions about gifts can you decide for them. If you believe it's in their best interest to give gifts, think about the person's wishes, views and values and how these might affect what they would give. What family members and friends think that they would have wanted, whether they might regain their capacity and be able to make decisions about gifts, then their current needs, just because someone used to give very generous gifts, can they afford to now? Unless the power of attorney says otherwise, you can make a gift only if it's either a gift to a relation of the person, such as a wife, a brother or niece. It can also go to someone connected with the person, such as a friend or colleague on a customary occasion, such as a birthday or Christmas. Or a gift can go to a charity that the person might have given to if they had mental capacity. In both cases, it's essential the gift is of reasonable value given the size of the person's estate, which includes all the money and property that they own. If the gift doesn't meet these criteria, the attorney has to apply to the Court of Protection for approval. To decide whether you need permission from the Court of Protection, you need to be able to answer yes to 3 questions. First one, is the gift to someone related to or connected with the person or to a charity they might normally have given to? 2, if the gift is to a person, is it being made on a customary occasion? And 3, is the gift of reasonable value given the size of the person's estate and their expected future needs? If you want to change the limits on the gifts you can give as an attorney or give a gift to a new organisation or individual, you will need to apply to the Court of Protection. The Court of Protection has a detailed procedure for agreeing any gifts, which include standard application forms and a set of published fees. The £365 fee is payable when you start an application. These fees do change from time to time, and the Office of Public Guardian website contains up-to-date information on the fees charged. So I'll put a link in the description below. With any application, the Court of Protection will consider the circumstances of the donor and will not approve any gifts that would prejudice the financial circumstances of the donor. In other words, if the donor would not be able to meet their expenditure commitments by making the proposed gift. The court pays particular attention to any proposed gift of the donor's home, where there is a possibility that the donor will end up needing to rely upon the state to pay for some or all of their future social care costs. You can check out my video on paying for care as a self-funder, which discusses the idea of deprivation of assets. So what happens if an attorney makes gifts to which they are not authorised to make? Of course, if the donor is still mentally capable, they could give the gifts their approval after the event, if they choose to do so. However, if the donor is no longer capable, legally the gifts will be treated as void. This could have severe consequences on the death of the donor, where the unauthorized gifts will be treated as being in the donor's estate. The most important impact would be on inheritance tax, which would still be payable on the gifted assets. Powers of attorney are becoming more popular, and it's certainly best practice to make a lasting power of attorney when you make your will. It's what I advise all our clients to do as early as possible. If you are looking for a financial advisor to help you with your retirement planning or inheritance tax and estate planning, make sure they understand what an attorney can and cannot do. Thanks for checking out my YouTube channel. I'm Justin King. My aim is to help people to live successful lives, and that often involves understanding your money. I hope you've enjoyed this video. Please press the like button to help more people like you find my channel, and check out the show notes for some useful links on the things I've discussed in this video. For now, I'm Justin King, helping you live your best life.